8 July, the Commission sent you a request for the submission of the 5-year declaration of assets and personal interest. And on the 15th of July, you submitted your 5-year declaration. The Commission also asked candidates to voluntarily complete and submit an ethics questionnaire, and you did so on the 5th of July. The Commission sent you 3 rounds of questions on 24th of August, 27th of September, and the 21st of November, respectively. You were asked a total number of 28 questions, including 71 subparts, and 25 of those questions included a request for further documentation. According to Article 3, Paragraph 4 of the evaluation rules of the Commission, a candidate may not provide information, documents, or other materials during the hearing if the Commission requested these earlier and the candidate did not provide them within the time specified, unless, of course, the candidate provides sufficient justification, therefore. Members of the Commission will now start with asking you questions. Nadezhda Ryepchevsky will start with questioning, following by Vitaly Miron. Nadezhda, you have the floor.
Thank you.
Good morning. I will start with the first round of question now. It's about the apartment that you purchased, the one that is a 72.2 square meters apartment, the one that we also had written correspondence. I will first introduce the facts and then we will move on to the questions. So according to the data available to the Commission in 2014, you bought an apartment of 72.2 square meters for a preferential price through a program for the improvement of living conditions of judges that was implemented by the Superior Council of Magistracy, the SCM. In your 2016 annual declaration, you put down that you bought that property, that apartment, for 25,884 euros. That is about 539,000 lei. When you submitted the request, the application for this apartment, you and your wife had the right of property already of an apartment in Chișinău with an area of 51.4 square meters that has been acquired through a donation contract in 1996. He also owned 3 land plots, and one of them had an area of 0.12 hectares, was located in Trușeni village, Chișinău municipality, and that you've acquired in 2012 on the 24th of May. For this land plot, on the 3rd of July 2012, you received from the local authorities a construction permit to build a house. At the time of the submission of your application with the SCM, you had already started the construction of the house on that land plot. And according to your answers to the second round that you provided to the Commission, that is. And thus, according to that, in 2012, you took a loan of 250,000 lei to both renovate your apartment in Chișinău and to initiate construction works for the house, right? And the Commission asked you to explain your eligibility for the preferential prices program, considering that there was the apartment and the house that you started to build. And you clarified in your answers to the Commission that at the time that the investment contract was entered into for the apartment bought under the preferential prices program, that at the time your family consisted of 4 people and was living in the 51 square meters apartment that was donated by your wife's parents back in 1996. You also explained that your children were already grown up and they needed more room, more space. They only lived in 11 square meters. alongside with the pets that you had in your family. And you also declared that you were proposed to participate in purchasing a larger living space, housing space, and you decided to seize that opportunity. You also confirmed to the Commission that you did not inform the SCM about the fact that you had already initiated the construction of your house in Trușeni village, because the income received at that moment was indicative of the fact that the house would be finalized in a distant future. You also stated that the difference in price between the market price and the at that time for similar apartments and the preferential price provided through the SCM program was not that essential, not that preferential. And you explained that at the time that the contract was concluded, the amount of the entrepreneur was 430 euros per square meters compared to 360 euros per square meter, which was the preferential price offered to judges, which meant a discount of only 16%, while many commercial centers and other subjects offered loyalty cards and promotional offers where the discount was between 10% and 30%. Now I will move on to asking some follow-up questions, and you will have the possibility to add further details after those questions. Please confirm that in 2014 you purchased the 72.2 square meters apartment at a preferential price through the SCM program. Yes, I confirm. Can you explain us when is it that you've applied for being enrolled in that SCM program? You know, I don't remember exactly. Either 2013 or maybe 2014. It was a short amount of time. There was this offer. Back then, I submitted my application that I don't know how long it took. I mean, there were some formalities in between. And then my application was accepted. And then the agreement was concluded. But you filed that application after you received the construction permit, is that correct? Yes. And at the time that the application was filed, thus, you already initiated the construction of the house. I initiated, otherwise the permit would be cancelled, annulled, so I had to start at least some construction. And you informed the Commission that you did not tell the SCM about the fact that you had already initiated the construction of your house. So please tell us if you don't, do you think this was ethical for you to do it, not to inform the SCM? Do you think that would have influenced in any way the SCM decision if you had told them about the construction of the house, about having started to build a house? Well, this might be subjective coming from me, but considering that I remember that at that time they asked what was the living space that we lived in, that we had. And considering that the initiation of construction works does not equal to living space, to housing space, I provided an excerpt from the Register of Real Estate alongside with the application. But about the initiation of the construction works, this was not something that was a criterion in the application. I just introduced the actual housing space that I had. But do you think this would have influenced the decision of the SCM if you had indicated that you started building a house? Sorry. I can't answer to that. So you don't think that it was unethical not to disclose the full information, in particular with regards to the initiation of the construction of the house? Now, speaking from the point of view of ethics through the perspective of the position of a judge and the Code of Ethics and Conduct, I think I did not. I think I acted within the limits of the ethical code, but from the morality point of view as a citizen, somebody who would like to improve the living conditions of the family. Also, considering that I've been working since 1995, I had 2 children and I didn't have my personal space. A lengthy operation, you could say, 20 years working, and you don't have a living space proper to give, to grant the proper conditions for your children to live in. I think it's ethical for the parents. If there are opportunities, the parents should seize them and should undertake actions to make sure that the right conditions are there. The microphone is off. Can you please? Well, you explained that, but we'd appreciate it again if you could explain again. Why did you say that the price that you purchased the apartment for was not a preferential one? Considering that there is a shortage of funds, well then any citizen would try to acquire a larger space, more space at a smaller price. And I've accepted it because it was an investment contract and it was not necessary to provide all the amount at once. So we could do that over a time span in 3 or 4 years, and so those were the conditions. But when you have the money and you can even negotiate a smaller market, a smaller price. Well, you mentioned the price, but the program itself, it did provide some facility to the judges. You couldn't have otherwise had the same terms. If you personally would have gone to any of the investors building apartment blocks, you wouldn't have been able to have the same conditions, the same terms, right? No, I wouldn't have. I cannot deny that, so I agree with the statement. And the next question now, before I move on to the next matter, I would like to provide a few more, to introduce a few more facts. So you sold the apartment that you bought for preferential prices, you sold it to your child, and I will use the word partner or husband-wife in Romanian, spouse in English, to not disclose personal data. So you sold it to your married child through a sale and purchase agreement on the 24th of December 2020. In your answers to the Commission, you declared that you sold that apartment to your child and child's family for the amount of 530,000 lei, which was about 25,000 euros. So it was similar to what you paid for that apartment when you bought it. You also explained that you and your family had never lived in that apartment that was purchased for a preferential price, thanks to the fact that you were in a position of a judge. And later on, when you were asked about whether you believed it was ethical to apply for such an apartment and never live there and then sell it to your child and their family, you explained that with your wife you decided to sell that apartment to your child, who at that time already had 2 children of their own, and you thought that as a parent it was your obligation to contribute to improving the living conditions of your child by providing them the possibility to live in a better space with their young family. And you also stated that your child's family did not receive the apartment for free, but that they bought it from you just the same way that you bought it in your turn. And thus that this meant essentially improvement of the living conditions of your family, considering that the living conditions of your child improved. Please confirm that you never lived in the apartment that you acquired. I confirm. And you sold it to the family of your child for 530,000 lei. That's right. And in addition to what I mentioned, can you confirm again? And can you explain whether you thought it was ethical to sell an apartment bought as a judge, by you as a judge, as a benefit for that position, and you never lived there, and then you sold it to your child? You would like me to explain or only to confirm? I confirm all the statements that I also made available to the Commission previously. There was an investment contract in 2014, and you couldn't have known at the time how family relationships would have evolved. And it happened that my daughter got married in 2017, and then she had the children, and the construction took some time until it was transferred, until the asset was transferred to us. So all of these circumstances then influenced this decision of our family, because we were living in that 51.4 square meter apartment. The family became bigger, it was 4 of them, and I will not, of course, tell you the secret of the family deliberations, but ultimately we arrived at the decision to give the children the possibility to actually live in that apartment, and they decided it would be fair for them to buy it so that they wouldn't have to depend in any way on the parents. We were not against it. So if I got it right from your answer, your child and the partner and the children, their children, they lived together with you until the apartment was sold to them. So practically in 51.4 square meters, they would partially live with us. So temporarily they would like in our apartment, and then temporarily in the apartment of the other parents. But we are located in Chișinău, so it was closer to whatever activity they had in Chișinău, because the other parents live somewhere at the outskirts of Chișinău. And you confirm what was mentioned, everything that was mentioned in the written correspondence, as in you believe that, and you still believe that that amounted to improvement of living conditions of your family. That is, the fact that you gave your child the possibility to improve their living conditions is like the improvement of the living conditions of your family. Yes, the improved conditions for my children and grandchildren. So that apartment was bought in 2020 by the family of your child for that amount that you declared of 530,000 lei. And when the Commission asked you about the method of payment, you informed the Commission that the entire amount had been paid to you in cash. And concurrently, according to the data in the information system of the State Tax Service, over 2017-2021, your child and your child's spouse earned taxable gross income totaling about 150,000 lei. And when the Commission asked you about the source of funds used by your child to purchase that apartment, in your answer to the Commission, you provided a copy of a loan agreement number 5, signed on the 14th of December 2020, providing for the amount of 530,000 lei. That was an agreement entered into by Pultusk Invest Limited Liability Company and the partner of your child. According to the publicly available information from B2B Hint, in 2020, that company had a net profit of about over 161,000 lei. According to the bank statement for this company on the 14th of December 2020, that is, the date when the loan agreement was signed on, indeed on that day, an amount of money was withdrawn from the account, but that was 190,000 lei. And that amount was withdrawn with the following mention: releases in the form of loans to natural people according to contract number 12 of 14th of December 2020. And the issued amount was to the father of your child's spouse, who is the respective company's administrator. Now, the Commission asked you to provide explanations with regards to the source of funds, and that is with regards to the remaining difference between the total amount of 530,000 and the withdrawn one of 190,000, and that is a difference of 340,000 lei. In your answers to the third round of questions, you explained that the method of obtaining the 530,000 lei was by receiving the loan from the aforementioned company by your child's spouse, and the amounts that were withdrawn from the company's bank accounts in two steps. The first one was on the 5th of November 2020, and at that time the amount of 350,000 lei was withdrawn, and on the 14th of December 2020, when the amount of 190,000 lei was withdrawn. You provided two bank statements for these two withdrawals. According to these bank statements and to the bank statement for the account belonging to the company, the withdrawal of 350,000 lei on the 5th of November 2020 was based on the contract, on the loan agreement number 11 of the 5th of November 2020. Similarly with the situation of the 190,000 lei, the 350,000 lei were withdrawn by the father of your child's spouse, the company's administrator, that is. These were the facts. They are complex, and we made them available to you, and you had the opportunity to have a look at them. Now we will move on to questions. So you confirm that the amount of 530,000 lei, the one that was given to you by the family of your child, so the source of this amount is the loan agreement between Pultusk Invest Ltd, owned by your child's spouse, and so the spouse took that loan from the company through the agreement of the 14th of December 2020. That's what I was told, and that's what I was given. And you provided this copy of the loan agreement. You provided it to the Commission, and that agreement stipulates, that is contract number 5, and you have a copy of that in the material. So do you confirm it's number 5, which is what you sent us? That is the agreement that I was given when we entered into the agreement. To be certain that the source was real and legal, I was provided that agreement. I do not know about the accounting part of it. You also said that the entire amount was given to you in cash, right? You also said that the only details that you knew about the company was that the spouse was the only shareholder and that the father was the company's administrator, right? Yes, I confirm. The Commission has also identified that on the 14th of December 2020, that is the date when the loan agreement was signed on, only the amount of 190,000 lei had been withdrawn from the account of that company. And that withdrawal had the next title according to the banking information. Releases in the form of loans to natural persons according to agreement number 12 of 14th of December 2020. So number 12. For the 190,000? Right. So could you explain why you provided us an agreement number 5, though in the banking information we can see agreement number 12. Can you please explain that? I cannot. I said that the way that the accounting part was done, how the accounting worked in that company, I don't know. At the time, well, I just asked for the document to be provided to me that testified to the origin of the sources. And that's what I was given. I was not able to change anything about it. Can you confirm that the Commission asked you to explain the source for the remaining 340,000? And in your answer to the question, you provided two bank statements, one for a withdrawal of 350,000, this amount having been withdrawn on the 5th of November 2020, And there's been another statement for the amount of 190,000 that was an amount withdrawn on the 14th of December 2020. Right? That is correct. And you specified that the amount of 350,000 lei was the 340,000, that is precisely the difference that the Commission asked you about. Is that correct? Correct. Now, again, according to the statement that you provided to us, the bank statement, the withdrawal of 350,000 took place on the 5th of November 2020 and was based on a loan agreement signed on the 5th of November 2020. And thus, on the basis of this information, we can deduce that that amount had been withdrawn for a different loan. It's a different loan indicated in the bank statement. And the second amount was withdrawn about a month before the signing of the loan agreement for the apartment, that is the one that contained the entire amount of 530,000, not 350 or 340,000. So please explain how did it happen that the amount of 350,000 is a source for the 340,000? How is that a source for the 340,000 that actually appeared after the 14th of December? It's just that these amounts do not come along all at once. Sometimes it takes years to accumulate those amounts. So when we decided to perform this sale and purchase, they were supposed to put together the amount of money. Now, about the ways that they did it, how they made some reservations for that, and how they accumulated it from the funds of that company, how they did that, I can't explain. On the 14th, I was confirmed that I had the entire amount and that we could conclude the agreement. And so it took 10 days, then the 14th of December, then the 24th of December. It took us 10 days to formalize it. And I guess the amount, it took them some time to put the money together, and there was the primary supporting documentation at the accounting department that was supposed to be drafted, but that it's up to them. As soon as they had the entire amount available, they confirmed they had it, and we moved on to drafting and getting ready the documentation for the sale and purchase agreement. But as for the ways and what they did and how long they waited, but you received these questions in writing regarding these amounts. And considering that you were the one who provided us those statements, you have perhaps also wondered about them. That one bank statement says agreement from the 5th of November 2020 for the amount of 350,000. And then another agreement, the one that was also provided to you the 14th of December with the 530,000 amount. So for any reasonable person having another look at those statements, it feels clearly it's two different accounts, 350,000 and 530,000. Have you never tried to clarify this matter with the person that sent you the money?
There are two different contracts, two different dates with different figures. That's what we try to clarify. Well, there's a 1 month difference between them. I did not clarify what the reason was for the statements to show two different contract numbers. I don't know what's the procedure. I don't know how they draft their documents when they withdraw money from the bank. Well, it's not only or besides having two contracts, two different contracts for the same amount. For the amount of 190,000, there are two contracts, one that you provided and one that is written in the bank account statement. And the second issue that I try to understand if you can find a reasonable explanation. In November, 350,000 lei were withdrawn, and there is reference to a contract, to a loan contract for that amount, 350,000 lei. What we understand is that we're talking about two different contracts, one in November for 350,000 and another one that was signed on December 14th for 530,000 lei. Do we understand it correctly? I did not get a final clarification. The only thing I asked is to provide what the source is in the context of a question that the Commission asked. And that was the net income that they have and the income sources, because there was a discrepancy. And I asked the question, where did the funds come from? Because such information became available. And I got the explanation that other amounts were withdrawn over the year. They explained me that the turnover of that company is quite significant, but two amounts not very far from each other were withdrawn, and they provided both of them. I mean, the second one, the Commission, on the 14th of December, the Commission already had it. And you did not try to clarify for the one on 190,000 lei? Why does it say one contract number in the materials you presented and another one in the bank statement? You did not manage to clarify that? I did not manage to clarify, and I didn't dare in a way, because you don't contribute in any way, but you ask for too many explanations about their activity and money that another family makes. Well, in a way, we are family members, but they have their property, their decisions, their family. I understood that. Thank you very much. Would you like to add anything to this subject, or can we move on? No. The following questions are about the transaction you performed on the April 16, 2021. Namely, you made a transaction to buy foreign currency, so you purchased a certain amount of euros. That's more or less the amount that you got for the apartment. And you explained the apartment that that transaction was made in order to purchase your car, and that purpose was done on the same day when this currency purchase operation was done. You also declared that the source of funds were the savings included or mentioned in your declaration for 2020. In that declaration, you declared cash amounting to 565,000 lei obtained from the sale of the apartment and the sale of another car of yours. According to the sale contract of the car that you purchased in 2021, April 16, that you provided to the Commission, the price agreed by the parties was $30,340 US, but the payment was to be done in lei. According to the payment receipt, also the 16th of April 2021, the amount of $30,340 US was paid in MDL in the total amount of 544,828 lei, and you provided the receipt. So please confirm that on April 16, 2021, you purchased 25,495 euros in order to buy your car, Toyota. Yes, that's right. And that was happening within the car salon. There was a bank office there. Please confirm that according to the sale purchase contract you provided, the agreed price was $30,340 US, with the payment to be made in lei, Moldovan lei. Probably. I can't recall. Actually, yes, that's how it is, because I remember the invoice was issued in national currency. So the payment you made on April 16 was the amount, the total amount in lei, 544,828. Yes, what's written in the invoice, that was exactly the amount. Could you please then explain why did you buy on the same day euros but paid everything in lei? What was the purpose of buying currency then? 25,495 euros. I don't remember what was the purpose. In that car salon, you can see the price in lei, euros, or US dollars. And what was the need to make that transaction? I can't remember exactly. But at the same cashier's desks, one and the second, and in the end, a receipt, a confirmation, a receipt was issued to me that the amount was paid. This is what we try to understand as well, because all the data that you provided show that you paid in lei, especially in Moldova. Money when you get an invoice, payments to get an invoice can be only made in lei. That's why we talk about this purchase of currency. Why did you buy the 25,000 euros? Maybe I did not buy. Maybe I made the transaction. I can't remember. Was it possible for you to buy 25,000 euros besides the payment? No. No, this was taking place in the bank office that is in car salon. If you have that information, you can see. It was in the car shop where they sell these cars. And there, on site, all these transactions were made. You just need to take documentation from them and see. Because it certainly was there. I got the receipt as a confirmation that payment was done. Would you like to add anything with respect to this matter about the apartment? If not, we can move on. Thank you. It's not clear to me. You purchased 25,000 euros on the day, and you make a payment for the car in lei. Is this transaction that you converted euros into lei, or did you keep the 25,000 euros, or what was the fate of those 25,000 euros? The Commission asked me about buying euros. I believe that they were not purchased. Probably I sold euros because all the acquired financial resources people usually keep in foreign currency. So maybe it was about selling currency and making the payments in lei. But right now, I don't know. When the Commission asked me this, and I was sure it was about that, I believe it was about selling the 25,000 euros, and subsequently transfer that money to the account of the company, right there, on site. Honestly, I don't remember if I sold or purchased currency, euros. Well, it seems to me that I was selling foreign currency, because this 530,000 lei is a bit difficult to keep in cash. How can't you remember? 25,000 euros is a big amount, and you can't remember if you bought or sold it. It's not clear. I don't understand. What was the situation? Probably I sold that amount. Yes. I will have to check to document myself once more. But when the Commission asked me that I bought it, and they was asking me in relation to what this purchase was, I remember that, well, different companies proceed differently, but here they issued me invoice in lei, but the transaction, well, I will check documentation about that.
But can I have one follow-up question to that? Because if you're saying that you sold, that you're not sure whether you bought and sold it, but you may have sold only 25,000 euros, then those 25,000 euros must come from somewhere else. Were they under a bank account somewhere? Did you have them as savings? Did you declare them anywhere? Where does those 25,000 euros then come from if you sold them on that day?
Well, it's the same amount that was in the savings, It's just most people keep their savings in euros. They exchange money over time, make currency exchange transactions, and they keep it in euros because they don't know exactly when exactly they're going to use. But it was the same amount obtained as a result of selling the apartment and the car. Well, maybe this can help you, but in the first round of questions, we asked you this question. According to the information available to the Commission, on April 16, 2021, you made a transaction of buying foreign currency worth 25,400 something euros. Please explain the purpose of this currency purchase, and you answered that the transaction was done in order to purchase a car, model Toyota, on that date. Meaning that you confirm that you purchased the currency. According to the information available to the Commission, it's purchasing 25,000 euros, not selling 25,000 euros. That's why we relied also on the answer received from you as a confirmation that it was purchasing euros, not selling. Right now, I am unable to answer. I need to check what was the transaction, a purchase or a sale. Hello, Mr. Șova. Before moving other categories of subjects that I'd like to approach, I'd like to ask you an additional question about the apartment. So in 2014, you obtained the ownership rights for an apartment under a program of SCM. This apartment was subsequently transferred to a family members of yours, and you explained that this is also a way of improving living conditions of yours. This property transfer was, it was done against payment. And some minutes again, you mentioned something that I would like to clarify. You said that actually the decision for this property transfer to be done against payment did not belong to the buyer, not to the seller. It wasn't your decision. It was your daughter's decision. And my question, and please answer in a way that I would have clarity about your position. So in the end, who decided that this transfer of ownership should be against payment? Did you decide, or the ones who bought it? The initiative was of the ones who bought it. And in the family, we decide that this is what we will do. Because the partner mainly mentioned that he wanted to own the property and not to be in a situation that is similar to mine. Your answer is accepted. According to the practice we already established, I will first describe some facts and then I will ask you some questions. And I will kindly ask you to answer. Just a second. I would like to ask you, first of all, about the land plot that you still own. This is the land plot from Trușeni village, Chișinău municipality. In 2012, your wife purchased a land plot for construction, 0.12 hectares in Trușeni, for the price of 20,000 lei. That was around 1,285 euros. And this was reflected in the sale purchase contract of 24th May 2012 that you submitted to the Commission. In your annual declarations for the years 2012 to 2020, you mentioned the cadastral value of the land plot, So not the contract. And the cadastral value of that land plot at the time of purchase and the one mentioned in the NIE declaration was 207,564 lei. And the Commission asked you to explain the difference between the cadastral and contractual value of the land plot and whether you can believe that the price of 20,000 lei in the contract reflects the real actual value of a property at the time of purchase. You explained that for the years 2012 to 2020, the cadastral value of that property was 207,564 lei. This is what you declared in your declarations. You also explained that you do not believe that the price of 20,000 lei reflects the actual value at the time of purchase, but that the price mentioned in the contract was the result of some direct negotiation between your wife and the seller of a land plot. Mr. Șova, please confirm that in your answers to the Commission, you stated that you do not believe that the price of 20,000 lei reflects the actual value of a land plot at the time of purchase, but with the comment that the price resulted from direct negotiation between your wife and the seller of the land plot. I confirm. Do you have any explanation? Could you please mention any circumstances or conditions that allowed your wife to negotiate a price that is lower than the market value? The price mentioned there was a condition set by the seller in order to conclude the contract for a lower price. My wife accepted that the contractual value would be 20,000. And I confirm that the price was not real, and that's why in my declaration I declared it for 200-something thousand. Given this explanation that this statement during the hearing, could you please confirm what was the real price paid for that land plot? I am not sure to declare that without the okay or from the seller, but the price was around the cadastral value. I'm not sure I can disclose without the seller's acceptance to disclose the value, but I honestly declare that it is about 200,000 lei. Okay, we accept that answer, around 200,000 lei. But I have to inform you that the Commission has the obligation, according to the Special Law 26, to analyze the way of getting this good acquired. So you have the obligation to declare information that is true and real. I had some additional questions because I did not understand if that price was 20,000, and then you previously mentioned that you had no connection with the seller. I wanted to ask you about that, but since you provided this additional explanation, these questions will be skipped. Let's move to another real estate piece that your family previously owned. And that is 0.06 hectares in Stăuceni and unfinished construction. It was 66% finished. In fact, you and your wife acquired a land plot with the area of 0.06 hectares and an unfinished house in Chișinău municipality on May 2nd, 2002 that was sold. Subsequently, on 11th of March 2011. According to the sale purchase contract of 2nd of May, you purchased this property at the price of 55,000 lei. That would be around an estimated of 4,290 euros in 2002. But then according to the sale purchase contract, when you sold this property in 2011, I remind you, we're talking about 0.06 hectares and a house of 99.3 square meters, being with the construction 66% complete, for a price of 14,161 lei, that would be 867 euros. Were the facts right? Yes, according to the documents. Please confirm that you bought this land plot in 2002. at the price of 55,000 lei. I confirm. This 55,000 lei price paid in 2002, was it real? Was what you really paid for this goods? Honestly, I can't recall 2002. What was the currency exchange rate and the price? Probably it was real. In May 2002, you were not a judge yet, 2005. In 2002, I was working as a lecturer at the university. Please confirm that you sold the same property, 0.06 hectares in the house mentioned before, on March 11, 2011, for 14,161 lei, which is estimated 867 euros. It was alienated, yes, but about the price, there were negotiations, again, between seller, buyer, and we decided to mention this amount. We decided to mention the amount of 14,000 lei. What was the real situation? In reality, the amount was big, around 200,000 also. Do you have anything to add in connection to this? But if I may, I will withdraw my question now because I see that my colleague has an additional question. Just a clarification, and thank you for mentioning this. Could you please explain why in both contracts? Because I understand that when you negotiate and things, but what's the reasoning? What's the rationale? Especially the seller's rationale to show such a low price. During that period, almost everyone was doing the same, showing smaller prices. And the seller's rationale, I can explain. It's about capital gain. So, Mr. Șova, do you want to add anything else, or can we move on to another question? Additionally, I just want to say that equally, that was decision to sell it, because for 9 years, we haven't done almost anything. We bought that real estate, but we were not able to do any changes to it, and later on, I decided to buy something else further on, and for that amount, you could buy a larger land plot. And that was, those were the times. Everyone was showing smaller than real prices, and that was it. If you don't mind, I would like to discuss about your declaration that you filed, especially the annual declaration of 2009, and on the factual description, you have this information. According to the data available to the Commission and information from that annual, you did not declare the following real estate or land plots, actually. 0.075 hectares land plot in Staucheni, obtained in 2003. Another land plot, also 0.075 hectares in Staucheni, in 2003. Another one, 0.026 hectares in 2002, house of 105 square meters in Staucheni, acquired in 2002. Another 0.06 hectares land plot in Staucheni, and half of 2.018 hectares land plot in Rezina that you acquired as an inheritance. in your subsequent declarations, you declared these properties. So please confirm that in your 2009 declaration, you did not declare these 6 properties. I confirm and I can explain. Please, of course. I confirm that period was just the beginning of the declaration period, and I followed the template. And in the template, it was said that you should mention financial assets obtained in the declaration year and goods that were obtained in the year of declaration. Subsequently, the ones who developed the template, they changed it from obtained into held. So I followed the template, and I mentioned only goods that I acquired, obtained in 2009. In the subsequent year, I declared I did not have any intention to elude, to avoid. No, I just followed what was written there. Also, in your interaction with the Commission, you said that you did not have any intention to hide these goods, and indeed you declared them later on. But given the provisions of Law 1264 of 2002, that at that time, saying that all goods were supposed to be declared, accumulated at the date of submission of the assets and property declaration. Now, at the hearing, do you agree that you should have declared all these properties in the declaration of 2009? I agree, I accept. But that was done in a hurry. It was the beginning of this declaration regime, so I just declared what exactly was written in the template. Mr. Șova, I would like to additionally discuss about the right to use car, model BMW 2006. You know this topic. We discussed about it during the Q&A rounds. Some facts. According to the information from Access Web, for the period between 22nd of October 2015 to 2021, you had the right of usufruct for car model BMW, make year 2006. In your annual declarations for the years 2015 to 2020, you did not declare the right of usufruct over this car. The Commission asked you to explain why you did not declare this right, and in your answer you said that this vehicle was always in property possession and usage of your father-in-law. You explained that this car was given to you only once to travel abroad in the autumn of 2015 because at that time your car was having some defects. I think, was it right what I described? Yes. Well, according to the information from Access Web, you had this right of usufruct over the car, and the Commission asked you a question about it, and you did not contest that actually there was right of usufruct registered appropriately regarding this car. Is that right?
A mandate was established as in a document that is equal to the right to usufruct, and that sort of a mandate, back in 2015, it would give you the right to travel, and if you traveled abroad, you had to have a certificate of registration. And practically, the father-in-law has filled that in on the day that I was to travel abroad, because my own car was is not in an operational condition, so I used that permission, that permissive mandate for 1 year, and that's what it said there, that it was for that period, and I did not need it anymore. And when it expired, it just did. So it was for a period of 1 year, not for the entire period. But I only used it to travel. I think it was 10, 15, or 13 days, or however long it took. And then I never again sat behind the wheel of that car, and I never used it again. I never traveled by it again. It was just a ride given to me for a year, and I don't know how it was until 2021, 2022. Well, that was exactly my question. What do you base this on when you say that there is right of usufruct registered with the authorities, and you say it was only for 1 year? But where are you taking this from? And looking at the information on Access Web, it's clear that the period is different. The 22nd of October 2015 till 2021. Well, once the period lapsed out, I no longer kept that empowerment, that mandate that allowed me to have this right of use of fact for a year, and I never used that again. So you mentioned that you used it once and that you traveled, you drove that car because your car was not operational, right? Okay, that is clear. Now, according to the provisions of Article 4, Paragraph 1b of the Law 1264 of 2002, and according to Article 4b from the Law 133/2016, speaking about a different period because the law has been enforced in different periods of time. So the declarants were supposed to declare their movable, immovable assets, including the non-finished one that they had in their ownership with the right of use of fruct, of superficies, habitation by the declarant and the family members, their cohabiting partner, including as beneficial owners of their possession and their mandate, commission, fiduciary administration contracts, agreements that transfer property and transfer for use rights. Do you agree that you should have declared the right of use of fact over that car in your annual declarations for 2015 and 2020? As we can see that in that period that right was there. Well, that right emerged from that mandate that was granted to me. It was a document whereby I was given the right for use, but in reality, it was not in my use. There was only the right to, but the asset was not in my use. It was only for a temporary period of time. And I believe that although the law has those provisions, but is when you are actually the one using an asset without being the owner of that, if you're using it for a longer period of time, then you must declare it. But in my situation, I hadn't used it for a long period of time. I've used it temporarily for 15 days at most for that trip, but no longer. I mean, we did the formalities for the right of use of fruct, but I did not actually capitalize on it. I accept this answer. Now, moving on to a different category of questions. This is going to be the failure to declare certain bank accounts. And according to the information available to the Commission over 2012-2015, you did not disclose the following bank accounts. For 2012, there were 2 bank accounts of your wife, bank account, and I will not name them in the long form, so you can see them numbered. So number 1 opened on the 18th of October 2012, and the bank account number 2 from the 5th of December 2012. Now for the year 2013, your bank account number 1 opened in 2013, and 3 bank accounts of your wife. You can see them right there in front of you. And then for 2014 as well, you can see your bank account number 1 from 2013 and 2 bank accounts of your wife. Now, the accounts above were active. There were inflows and outflows as follows. So on your bank account of 2013, account number 1 opened on the 19th of March 2013. It was an active bank account, and in the period 2013-2015, you received payments with a mention with a note salary transfer, and the amount of that was 60,000 lei. Your wife's bank account from 2012, number 1, that would be an active one, and in the period 2012-2013, your wife received payments with a mention of payment, a client contract, and the amount is 321,000 lei. Then your wife's bank account, the second one, opened on the 5th of December 2012, an active bank account on which your wife received funds totaling almost 186,000 lei in 2012, and the amount of 162,433 lei in 2015. And then your wife's bank account of 2013, number 3, that is, in our annex, opened on the 27th of July 2013, an active bank account, and in the period of 2008-2013, your wife received funds with the note that is funds uploaded were deposited on the card. Now, and the amount of that was 376,000. And according to the provisions of the law, the declarant had to declare all bank accounts open in their name and on the name of their families after 2016. According to Article 4, Paragraph 1, letter D of the Law 133/2016, the declarant had to declare all bank accounts opened on their name, on the name of their family members, if the cumulative value exceeded the amount of 15 average monthly salaries in the economy. Now, a question is, why didn't you declare these accounts in your 2012-2015 declarations? Actually, I was declaring all the accounts mine. I mean, if we speak about my account, if it was a salary bank account, and if it's that amount, the 6,000 account, that were perhaps salary payments from the state to university, because I worked there. I had a Victoria Bank card, or there was the Banca di Economie or Banca Socială, and then when there were issues with those banks, I had a card with Victoria Bank, and I guess this was a bank card from the State University. Well, that's what it said, the note, salary transfers. Well, I thought I indicated all of them. I had a Victoria Bank account that I declared. I looked into my declaration, so maybe just inadvertently didn't do it. And I even asked my wife about her accounts, and it was like there was this consumer account, and sometimes the term would expire. They would give another card. Maybe the number of the code would also, the number of the account also changed. So maybe that's what led to this confusion. But it might have also been a situation where it was an account opened on the name of the notary office, where they would also take services not only paid in cash, but also by transfer. So, but you can see there is the breakdown. I see the breakdown, and I'm looking at it, and I think that maybe it was those two bank cards, the consumer ones, with the 150,000 there, because she would put money on those accounts and then withdraw them upon need. And then the Molding.com bank account, I asked her, and she didn't tell me she had a bank card. She perhaps had an account with a bank or tied to the notary office. But the notary office is different, is separated from the individual, from the natural person. But I would like to ask you, do you disagree with the information that we introduced you to regarding the existence of these bank accounts? No, if the Commission has this information, well then we've established that you agree with this information. And starting from the provision that I just quoted, the Article 4, Paragraph 1, letter D, and the letter of the two different laws, those differences of situation until 2016 and after 2016, and those provisions that apply this in law. So you had these active obligations and you did not declare them. So that was the question. What was the reason for not declaring them? They existed. You agree now with them having existed, and they were not declared. And so what were the circumstances and what was the reason for not having declared them? I am trying to explain. There was the Victoria Bank one. And what I had, when I was supposed to fill in the declaration, I looked into the bank cards because I didn't have accounts. And as for the wife, I could confirm, but just now. But at the time, I was not told. I indicated the credit card or that type of card. So those that I knew of at the time, that I had knowledge of at the time, I declared. And the others, I might have overlooked it inadvertently or because of not knowing about them. But at the end of the day, we need to elucidate these matters as well about declaration, non-declaration. So you did not indicate them in the declarations as set out in the law because, now speaking about your wife's accounts, because you did know that they existed, or was it that you overlooked it inadvertently? Because these are going to be two different scenarios then. If now, when these additional questions were asked, I've asked her, and she said, I told you about all of them. So I don't know. You should have. I'd rather say this is, and I overlooked it just. But we also asked you previously in the Q&A rounds, we asked you about it, but that's the same that I received as an answer from her, and I asked her to clarify with the bank so that we have a better clarity and understanding about what the situation was about that account. So. Apologies for having interrupted you. Please continue. Well, to make it clear for the Commission and everyone, I think perhaps I just overlooked it inadvertently, and maybe even not even knowing. That was the question, so we need to try to get to the bottom of it, but what prevented you from providing an explanation even before the hearing? Because at the end of the day, I don't understand. Do you recognize the existence of these accounts? I also quoted the provision of the law that demanded of you to declare that. When I ask you why you didn't, I still, well, don't get upset at me, but I still don't get a clear answer. Was it an inadvertent, you overlooked it inadvertently, or did you not know about them, which would not mean an inadvertent omission because you didn't know about them? Now, as regards the bank card that I had, I think it's just I overlooked it inadvertently because I knew there were payments coming from the state university for that particular period because I also had a part-time job there, so there were obviously certain money coming there. So an inadvertent omission from me. When I asked my wife, she said, I told you everything that I had. I don't know more than that. I don't know more than that. As regards her bank accounts, I would rather say that out of not knowing, lack of knowledge about it. Now, with regards to the next matter, again, this is something that you should also know about. It's about the loan of 150,000 from Victoria Bank. In your 2012-2013 annual declarations, in debt, you indicated a loan of 150,000 lei with an interest rate of 17% from Victoria Bank. In your 2014 and 2015 declarations, you no longer declare that as a loan, but as a bank account, with 150,000 lei on it with a 17% interest rate opened in 2012, and that in the financial assets column. In your subsequent declarations for 2016 and 2017, you declared again a loan of 150,000 lei at 17% interest rate from the aforementioned bank, and that is to reach maturity in 2018. Now, that was under the column debt. When you were asked about why you did not declare the loan as debt in 2014-2015 declarations, you stated that that was in the financial asset column of the declaration because in your perception, you thought that you had to declare it there. Now, the loan agreement with the bank had been signed by your wife on the 7th of November 2012, and the object of the contract was the amount of 150,000 lei, as previously said, for the 17 interest rate, and that has been a floating rate. And what is important to mention is that that card was like a consumer credit card, and the Commission asked you to provide bank statements regarding that bank account for the period of 2012-2018, and you were not able to provide those statements for the entire period, though you provided them for 2012 to 2016. According to these withdrawals for 2012 to 2016, there was incoming flows of 402,513 lei and outgoing cash flows of 502,599 lei. Now the questions. For 2012-2013 and 2016-2017, these are two different periods, did you declare this loan as debt? Is that correct? If I did that in my declarations, then yes. And for 2014-2015, you declared this loan as a bank account under financial assets category, right? Yes. That was like a credit card, Can you explain us what happened, what was different for these periods 2014-2015 compared to 2012-2013 and 2016-2017? So, what was the reasoning behind directions? As in the same situation was just addressed differently. Nothing happened. It just reflects the way I understood the template of the declaration, as in put down the cards. And since she had a card and there was the consumer credit on that card, I put that down in that category that I thought was right. And then on another occasion, after giving it more thought, I put it down for debt, as in the debt column. But in fact, these are 3 different periods, and you kept changing your mind about it. Initially debt, then not debt, then back to debt. So what was the logic behind it? There were periods of time when the card would be paid in by my wife, and then there wouldn't be a debt. And then when there were times when we would withdraw a bigger amount, it would look like a debt. And so she wouldn't have the time to put money on the account on that card to the extent required. I guess that was the situation, because I did not have any intention. I did include it in the declaration. Article 4 of the Law 1264 of 2002, in force until the 1st of August 2016, provided for your obligation to declare all your debt as debit. And now, do you agree that you should have also reflected as a debt in your 2014-2015 declarations? Now I think I need to go back and review all of these matters. I should have indeed declared that both in bank cards, both in the debt column. Thank you very much for your answers to the questions of the Commission chairperson. I no longer have any other questions. Mr. Șova, I would like to address now the last set of questions. And you already noticed, the facts have to do with the case that you examined. And according to the information available to the Commission, in 2020, you examined a request for the establishment of insolvency for OMV Group, limited liability company, submitted by Exim Bank on the 24th of June 2020. And by court decision of 22nd of January 2021, you accepted that application filed by the creditor Exim Bank. And you found the insolvency of the debtor, that is of the company OMV Group, and you ordered the initiation of the simplified bankruptcy procedure with the dissolution of the company OMV Group. During the examining of the application submitted by Exim Bank against OMV Group, there were at least 2 requests of recusal submitted against you. And the basis of that, there was for instance, by decision of the 31st of October 2020, another judge rejected that request of recusal. And by decision of the 21st of January 2021, another judge rejected, yet again, a second request of recusal that was submitted by the same party. On the 2nd of November 2021, you recused yourself from examining the Exim Bank case, the case of Exim Bank against OMV Group. And you explained to the Commission that during the parliamentary hearings on the 3rd of March 2021, before the legal committee of the Parliament, and in the context of your participation in the competition for the position of judge in the Supreme Court of Justice, there you were asked questions, rather in the form of accusations, with regards to your participation in the aforementioned case. You told the Commission that you took those accusations as intimidation and as bias regarding your impartiality in examining the case. And you believe that once it went out in the public sphere, this could determine third parties, observers, to believe that you were not impartial in further examining the case, and hence you submitted a self-recusal request on the 2nd of November 2021 that was examined and accepted on the same day by another judge. Are the introduced facts correct? Yes, I confirm that those were the events. So you confirm that you examined the insolvency request of OMV, regarding OMV, that was submitted by Exim Bank. Yes. And can you confirm that along the way there were two other applications, two other requests, recusal requests, and both of them were rejected? Is that correct? Can you remember what were the grounds for you to recuse yourself? Without telling us, if you can't explain without disclosing information related to the parties concerned, then we don't have to answer it then. No, but it was there also in my detailed answer, and I can confirm again, because it's sad that previously, a few years ago, the representative of OMV Group was involved in a litigation, was part in a litigation. I was a lecturer in university, and there was a power of attorney, but it was indicated that I was a lawyer, and we were in the two different parties in a civil case. And therefore, because I was representing a party, the party that lost the case. And that was like a ground that I would be biased, or that I would take revenge, as it was written in the request, that they would expect me to take revenge because years ago I was on the losing side. And the other reason is, I guess, because I didn't want to keep postponing it. There were different requests to postpone. But the insolvency law provides for a limited time of 60 days for examination of this category of cases, but it kept taking time, over about 4 or 5 months. Thank you. Can you confirm that you submitted your self-recusal application regarding this case on the 2nd of November 2021, and that you... So you did. I confirm that. And you submitted that request only because of the questions that you were asked by the legal parliamentary committee during the hearings on the 3rd of March 2021, given that you were running for a position of judge in the Supreme Court of Justice. Is that correct? Yes, I confirm, because the materials related to the case, in the case file, there was a first page that had to do with the request of the representative, I'll call that went to all those institutions, to all public institutions, and there was the first page, and it had the content that led to the questions that I was asked during the hearing in the Parliament. And can you confirm that you appreciated those questions as intimidation and as sort of prejudice related to your impartiality? That's how you appreciated those questions that were asked on the 3rd of March. I confirm that by that time, several circumstances developed that no longer allowed me to continue with that procedure. No, I mean that you confirm something else in your answer provided in writing to the Commission. And you mentioned that the questions that you were asked during the hearing in the Parliament on the 3rd of March, you would have rather rated that as intimidation and as prejudice regarding your impartiality. Now, in this regard, did you file an application with the SCM where you would have claimed intimidation that you were subject to, or did you file anything else to any other body? No, but I did not file anything. I asked from all the bodies information regarding the circumstances, and they all rejected my request. I wrote to the presidential office, but you'd never filed a complaint with the SCM where you would have claimed intimidation at the hearing in the Parliament. That is right, I did not file. There was intimidation from the participant in the process. I mean, they went to all the courts and they complained to all the institutions to complain, because they claiming that I would be somehow influenced in a way as to take a biased decision. But they kept making me write explanations, and that could lead to certain bias. But can you explain whether those accusations those accusations that were made by one of the MPs, right, at that hearing. But those accusations, did they affect your capacity as a judge to continue to examine that case in an impartial way? I can't say that I was affected. However, considering that a reasonable third-party observer, I wouldn't want such an observer to believe that I might have maybe been affected. And to avoid that, I decided to recuse myself. And it's the Bangalore Principles 2.5. They set out that it's not only the judge it's not only when the judge feels that they can't examine a case independently and impartially, but it must be that a third-party observer must also have the feeling that the judge has the capacity to examine properly, as set out. But the politicians, because you mentioned that, so they can ask different questions of that nature for different cases, or they can make some statements for the media. Would you recuse yourself every time when that would happen, when something is alleged in the public space about, say, for instance, your lack of impartiality? No. But what made that case different? But well, in order to avoid future suspicion, I thought it was right to file that self-recusal so as not to have third parties suspect that I might have examined the case while being influenced by all sorts of pretexts, either of psychological nature or of a different nature. Can you explain another thing? The hearing took place on the 3rd of March 2021, but you submitted that self-recusal application in November 2021. How come there was such a long time? It was the time of annual leaves, a huge workload, and the meetings kept being postponed, the sessions, and then in the meantime, the second appeal had been also examined, because I had pronounced that judgment, and it was appealed in the hierarchically higher court, and then it took some time with that, with the appeal, and then August, September is usually the annual leaves period. So that's, I guess, that was the first meeting actually that took place. In the parliamentary hearing, when those allegations were brought forth, you also provided answers on that case? No, because I did not prepare in advance. Right there, at the commission hearing, I was asked those questions, and you answered those questions, right? Yes. As far as I could remember, but I hadn't prepared for it. But do you think it was ethical to answer questions asked in a parliamentary hearing regarding a case that you were examining? Questions asked by a politician, do you think it was ethical to answer them? But I did not disclose the circumstances of the case. I spoke about it in general terms, as in I was aware of that matter. And in materials of the case, I said that there was a complaint filed to all public authorities. It was the first page that appeared, and there was a stamp of it having been registered with the prosecutor's office. And the text, as I remember, were exactly the questions that were asked. So that's what I said. I said there was that complaint, that petition, but I did not disclose all the circumstances. I rather spoke in general terms. If this situation happened again, would you have done things differently, or would you have done the same thing?
If I were to turn back and if I knew the result or the effect of that, probably I would have declared self-recusal, but I didn't have reasons. If I knew what this would have led to, probably I would have declared self-recusal, but there were no reasons for me to do that, because I explained to the Commission. because I had multiple cases with the creditors, and we talked about credits with Victoria Bank. The question is why you declared self-recusal, because it results that you declared self-recusal under pressure. That pressure that was applied by the parties, and as a result, you declared self-recusal. Maybe you shouldn't have. Maybe you shouldn't have answered to that MP. If you felt that that is intimidation, you should have said immediately, this is intimidation, I don't answer to such questions because this is wrong according to the judge's code of ethics. Or not? I believe not, because once they summoned me to a hearing, I can't say that I don't answer to the questions that the specialized parliamentary committee was asking me. So, in line with the Code of Ethics, without disclosing circumstances of the case, because at that time there was already a decision issued by me on that case, on starting the bankruptcy proceedings under simplified procedure. Yeah, it wasn't irrevocable, but and according to the Article 1 of the Code of Conduct, I should have refrained from making comments on circumstances of the case that I remembered and expressed in my decision, and I did not do it. But you know, since they came with direct accusations towards me, I was supposed to answer, because in my opinion, those accusations were almost of a criminal nature, already of a criminal nature, sorry. So I had to answer. And if I stayed silent, it would be me accepting what they invoked. I understand that. Thank you. Would you like to add anything further on this? No, I will refrain from, because otherwise I would have to disclose all case circumstances. No, not about the case. As you can see, our questions are strictly about the way you declared self-recusal, and did you have to do that or not? Because from what you said, things can be interpreted, and that's why I asked you, would you like to add anything about this or not? I just want to say that, well, since we talk about this case and my behavior, I would like to say that I acted purely unbiased, examining this case, focusing on all circumstances and evidence provided. Because in my vision, and my decision was held by the Superior Court as well, which means I issued a legal and justified decision, and I was not influenced in any way. So I believe that the solution was one and the same, even if someone else tried to examine it. So then and now, the solution of that case was what I decided and couldn't be different. I have a question towards you. You know, if the situation repeated, would you proceed the same or in a different way? Madam Raducanu, from the perspective of how I solved the case, or no, your behavior is if such a situation repeats. We are not talking about the case, how you examine the case. The situation, you know, with hearings at the committee, self-recusal and things. If such a situation repeats, a similar one, would you proceed in the same way or differently? Would you behave in a different way or the same? I tried to say that right now, I believe that in order to avoid all the effects that were produced and that are known to me right now, maybe I were to declare self-recusal, just depending on, because circumstances that on which I relied when I declared recusal last time, those circumstances happened after the. So you think you proceeded correctly, and if it happens again, you do the same. Did I understand correctly? Yes, thank you.
Are there any other questions from any of the colleagues on this side of the table? No? Then I think we're coming to the end of the questions to you. If you would like to, we give you now the opportunity to make a brief closing comment from your side. So please go ahead.
Thank you. I would like to say that this was an unusual exercise. It was an exercise that will make me, in the future, to pay more attention to keeping records of my financial material operations and to be more thorough in declaring all, so to declare everything I have to declare in my declarations. And for me, this evaluation is very similar to the situation when the parents, when they see that their child is sick, they say, let's carry out some tests and see. Even though that's not always pleasant, but in the end, it's to the benefit of a child, because in the end, like, it will be found out if the child is sick or not. And I would like to just apologize now in front of the public to my close people if I generated some inconvenient aspects to them in the context of all these checks and requests for information otherwise. Thank you, and I think this will be very useful for all the declaration of income operations things in the future. Thank you.
Thank you very much. With that closing comment from your side, we come to the end of the hearing. I thank you for answering all the many questions that, of course, the Commission had for you. The Commission will now withdraw for deliberations, and in principle, we try to get a decision out in your case within a month after the date of this hearing. I hereby declare the hearing closed, and thank you again for participating with us and answering all our questions. Thank you.